Welcome to this training for SDEA members on disability accommodations. My name is Morgan Thornberry and I'm a staff person at SDEA. Disability accommodations are a matter of law, and in this training, you'll learn what workers need to know about the law. Here's what we're going to cover: workers' right to reasonable accommodation, when to request a disability accommodation, how to request a disability accommodation, the interactive process, and legal services for SDEA members. You might want to take notes, so I'm going to pause for a few seconds so you can get your note-taking tools ready. The Americans with Disabilities Act, or ADA, is a federal law. It has a lot of provisions to protect people with disabilities. Just one of those provisions is to protect people with disabilities at work. A specific protection is that it requires employers to make reasonable accommodations for an employee's disability so they can keep doing their job. Let's look more at the terms reasonable accommodation and disability. Up first, disability. Disability is defined in the ADA as a physical or mental impairment that substantially limits one or more major life activities. Major life activities are things like walking, lifting, hearing, concentrating, focusing, standing, grasping, pulling, breathing, sitting, speaking, and so on. Typically, when we think of disability, we think of conditions like deafness or using a wheelchair. Those are disabilities, but under ADA, other conditions could be disabling too, including adult attention deficit disorder, migraines, obesity, chronic pain, premenstrual dysphoric disorder, and alcoholism or drug addiction. Just because you have one of these conditions doesn't mean you're disabled, but these are examples of conditions that, depending on how they impact your ability to do your job, could be considered disabling at work. Now let's look at reasonable accommodation, which is defined in the ADA as a modification or adjustment to a job or work environment that will enable an employee with a disability to continue to perform the essential functions of their job and enjoy equal benefits and privileges of employment. In the time of COVID, reasonable accommodations may also look like additional PPE, clear masks, reassignment to a position with less contact exposure, and so on. The Job Accommodation Network, for which I'll give you the URL at the end, has an A to Z list of accommodations that you might find helpful. Let's also talk about what a reasonable accommodation is not. It's not any accommodation you ask for. It must be reasonable. Reasonable is a tricky word, but generally it means that if the accommodation does not create an undue hardship on the employer, then the employer has to provide it. An example of an accommodation that would create an undue hardship is if you request a new job and that job doesn't currently exist. It's considered an undue hardship for an employer to have to create a whole new job with a whole new set of job responsibilities for an employee because of their disability. You can request a disability accommodation at any time. You get to decide for yourself when the right time to request an accommodation is. To request a disability accommodation, you can use the district's three-part application, which includes employee statement, supervisor statement, and healthcare professional statement. The items in red, the first and last items, are your responsibility to provide. You can use the form and/or a letter from yourself or your healthcare provider. The district's forms may say that your healthcare professional statement must be from a physician, but that is not true under the law. The ADA says it can be from an appropriate healthcare provider, which, depending on the disability, might be, for example, a physical therapist, a speech therapist, or a psychologist. At this time, San Diego Unified's application asks, what is the condition? What is the expected duration of the condition? How does this condition affect your ability to do your job? And what is the accommodation? Let me share some pointers now on how to write a strong statement in support of your disability accommodation. First, While it's not required, it is a good idea to meet with your healthcare professional before you go further down the path in order to avoid having to go back to them later and get something changed. It can be burdensome to have to make another appointment with your healthcare provider, wait for it to come around, all to get a few words changed on a document. We want to coordinate from the beginning to make sure you and your healthcare professional identify the same diagnosis, or the same disabling condition and the same accommodation. Second, identify yourself as a person with a disabling condition. You need to say a bit about how your condition affects you, but you don't have to disclose your specific diagnosis. Third, in your statement, you need to identify a limitation or specific problematic job tasks, such as cognition, standing, lifting, light sensitivity, being on time, and so on. Last, your statement has to request a specific disability accommodation. And although it's not required by the ADA, you may find it's a good idea, for the sake of clarity, to be really clear in saying that you need a disability accommodation. When you write your statement, we want to hit 3 areas. 1, identify that you have a disabling condition. 2, the problematic job tasks or limitations you have. And 3, the specific accommodation you need to do your job. Here's an example of how you can write that. I have a pregnancy-induced disability that causes morning nausea and interferes with my ability to be on time to work. I will be late to work on occasion and need these instances of lateness not to be counted against me. Again, ADA does not require that you disclose you're pregnant because that's your diagnosis, only that you have a disabling condition, like in this case, morning nausea. And note here that although pregnancy alone is not a disability under the ADA, many pregnancy-related conditions are disabilities an employer may have to accommodate under ADA. Let's read this statement at the bottom. I have been having medical issues that affect my mood, sleep schedule, concentration, and focus. Workplace distractions interfere with my concentration and focus. I'd like to request an accommodation so I can do my job effectively. I'd like to try noise canceling headphones to minimize sound distractions. So can you see where the person identified that they have a disabling condition? That's in the first sentence. Also notice that they did not disclose their diagnosis, but they did talk about the particulars of their condition. Can you see where they identified the problematic tasks? That's in the second sentence around concentration and focus and workplace distractions. Then notice the specific accommodation they requested, noise canceling headphones. Now let's look at how a healthcare professional can write a strong statement to support you in your request for a disability accommodation. First, a big reminder that the statement can be from the healthcare professional who's appropriate given your condition. It does not have to be from a medical doctor or physician. Next, if possible, it's a good idea to draft it yourself or draft pointers for your healthcare provider. You've had the benefit of this training and healthcare professionals usually have not. Based on the healthcare professional statements I've seen, I think a lot of healthcare professionals have misunderstandings about the ADA at work. The healthcare professional should identify that you have a disabling condition, like in your employee statement. It is not required by ADA that you state your diagnosis. So you don't have to say your diagnosis, but they do have to identify the disabling condition. The statement should explain how the limitations of your disability make job tasks problematic. And if the condition is temporary, it should state so and say the expected end date. But just a caution here, not to give a premature expiration date. Be realistic about yourself and your condition. Then the statement should recommend a specific accommodation. And that recommendation should be in line with the accommodation you request in your statement. It's important those things be in agreement. Okay, so once you've requested a disability accommodation, what's next? The employer, San Diego Unified, has to then engage in what is called an interactive process. The interactive process is a non-adversarial back and forth process with you and likely an HR representative. You'll brainstorm and try to problem solve. So they might say, that won't work because, but what about whatever? Or you might say that. They might have an idea for an accommodation and you might say, that won't work because of such and such, but I think this idea would work. This could be an ongoing process, possibly over multiple meetings. You have the right to bring a friend, coworker, family member, or an association representative to those meetings. If you're interested in learning more, here are a few good resources. First, the Job Accommodation Network. What's really valuable about this website is their A to Z list of disabling conditions, limitations, and accommodations. You can also find sample statements here. Really good resource. Second, good resource is the webpage from the California Department of Fair Housing. And this page in particular has some information about your rights at work when you have a disability. And the last is this webpage, what to expect when you're expecting and after the birth of your child at work, kind of a mouthful, from the US Department of Labor. You can use a search engine to find that one, but it covers pregnancy-related disability accommodations and non-discrimination. If you have more questions, you can talk to your site or program union representative. If they can't answer your question, we have an SDEA staff person who is dedicated just to taking calls from reps and can help them get the answer, but that's for reps only. So if the district denies a reasonable accommodation for a qualifying disability, or if the district unduly delays a reasonable accommodation for a qualifying disability, this may be a violation of your rights under the ADA. Since the ADA is a law and not provision of the union contract, it's enforced through legal means. If you're a union member, you have the right to union legal services, which is an extra benefit of union membership. The main benefit, of course, is being part of a movement of educators standing up for good jobs and good schools. To qualify for legal services, you have to be a member at the time of the event, giving rise to the need for legal services, though. To be a union member, you have to sign the SDEA membership commitment. You're not automatically a union member. You have to take this step to say, yes, I want to be part of my union, and you can do that online at the URL you see here. So we are all working people, and you probably have other working people in your life who aren't part of a union. In fact, in the US, most working people aren't part of a union and don't have the benefits of the protection of a union contract. But the ADA applies to them too. So share what you learned. Working people like you can help other working people know their rights at work.